Good morning, everyone. Thank you so much for joining us this morning for our Fair Housing for Maintenance Professionals. I am Brianna Miranda, Education and Outreach Coordinator, and joined with me today is Liz Keegan, Director of Education and Outreach. Some first housekeeping things. If you didn't see them on the way in, attendance will be taken through a training evaluation and attendance verification survey. It should appear in your browser. However, if it doesn't, we will provide the link. The survey must be completed by August 29th, tomorrow at 5 p.m. We really need people to complete those in a timely manner because we have lots of trainings happening at all the time. It's really important to get those in so we can get you your certificates. Everyone is muted and your cameras are off. We cannot see or hear you. Please use the Q&A to send any clarifying questions during the training. We'll try to answer them. Otherwise, we will have time at the end to answer some questions. Please don't use the chat for questions because sometimes questions can get lost there. This training is being recorded, and this training is sponsored by a grant from the U.S. Department of Housing and Urban Development. So this morning we will have some polls to start us off to get us brains thinking and just to get an idea of where you guys are all at, understanding your level of fair housing experience and whatnot. Then we'll go over who we are as the Fair Housing Center, some fair housing laws, the state of housing discrimination. We'll go over some criminal background screening, reasonable modifications and accommodations. Then we'll end with some best practices and some tools. So to start us off, I can get the polls. We're going to start off with a level of fair housing experience to begin. So on a scale of 1 to 5, please rate your level of familiarity with fair housing. 1 being I'm new and 5, no, I know a lot. And if you're with a group today, you guys will just kind of have to figure out where you stand as a group. Right, we'll give about 10 more seconds to get your answer in. All of these are anonymous and they're not really used for anything other just for engagement. So don't worry about your answers. All right. So we have a really mixed group. A lot of you fall into the I have some or you are new, which is really great. This is a really great class to kind of, we're not going to get into too much specifics, but we'll do some basic stuff, go over some basic stuff. We do have a 101 that we did last week. Yes, last week. And hopefully we, maybe, I think some of you have probably joined us last week as well. I know that there was a lot of folks that registered after our training last week. So going over the protected classes. Please check all the protected classes under federal fair housing law. So if some of you are new, this is a good way to get started thinking what could be a protected class if you're not familiar. We have about 30 more seconds here for folks to get in their answers. All right. So we're just going to go through them. So smokers are not a protected class. Actually, I'll just go through which ones are a protected class for the sake of time. Race is a protected class. So a majority of you did guess that, or I should answer that. Then we have religion. That is a federal protected class. Sex is also a federally protected class. National origin is a federally protected class. And disability is a federally protected class. Adult with dependent children, so families with children, that is a protected class, and color is a protected class. Credit history is not protected, and either is a convicted felon, nor is smokers. Those things are not protected by fair housing. All right, and then we have one last, or I should say two last questions to get our brains thinking this morning. Anyone can file a fair housing complaint, a resident, a visitor, a property manager, true or false. And then the second one, maintenance staff cannot be held responsible for stating a preference for certain types of tenants under fair housing law, true or false. I give about a minute for folks to fill that, answer those questions. Okay, give about 10 more seconds for folks. Righty. So the majority of you got both of these correct. So anyone can file a fair housing complaint. That is true. We do accept complaints anonymously as well at the Fair Housing Center of West Michigan. So anyone is welcome to file a fair housing complaint. We have had a lot of the industry file complaints as well to, just keep the industry honest, which is really great. The second question, maintenance staff cannot be held responsible for stating a preference for certain types of tenants under fair housing law. That is false. Maintenance staff can be held responsible for stating a preference for certain types of tenants. So it was a little tricky in wording there, but just wanted to see if you guys were alert and awake this morning. So thank you for indulging us in these poll questions. So now we'll move on and get started. So if you aren't familiar with who we are, we're the Fair Housing Center of West Michigan. Our mission is to prevent and eliminate illegal housing discrimination. We do this through ensuring equal housing opportunity and promoting inclusive communities. We do a lot of education like today and outreach as well. We also do research, advocacy, and then on the tail end as well, enforcement. So we do take complaints of housing discrimination and proceed from there. We were founded in 1980 as a private nonprofit as a combined effort to desegregate schools and integrate neighborhoods. We were founded by both the industry as well as the community. So that is a really important thing that we still try to honor to this day by providing education and best practices to the industry. We really are, fair housing is so important to us because we really honor the fact that where you live affects how you live. So having that choice is really important, and that should not be taken away from you. Here at the Fair Housing Center, we do not have any attorneys on staff. We cannot provide legal advice. This session is for educational purposes only. We are not an enforcement authority. We lead with education, seeking to prevent housing discrimination. Again, anyone can report housing discriminations. Our services are free and we let our clients lead the process. And then on the right here, you'll see a map of the different Fair Housing Center breakdown. We are the purple area, so we cover 38 counties. So we are a bit busy, as on the call today is Liz and I presenting, but Lindsay is behind the scenes, and that is our education department. So we do a lot for a big service area. So please be patient with us as we're answering questions and getting your certificates out and things like that. Some things that we don't do, because fair is a very subjective term in the world. So it can be really confusing what we do, understandably so. So what we don't do anything regarding landlord-tenant matters. We don't teach homebuyer classes. We don't teach credit counseling. We don't work strictly on affordable housing issues. However, fair housing is interweb, but we're not solely in that realm. We don't deal with building code and maintenance issues, and we do not do foreclosure prevention. So what is fair housing? Fair housing law is the right for individuals to choose housing free from discrimination under what we call protected classes, which are classified under federal, state, and local fair housing law. So we really work in the legal realm, even though we're not attorneys. So a lot of this is just based off of our impression of the law and our understanding of the law. Fair housing protects against discrimination in all housing transactions. This includes rental, sales, lending, and insurance. And as we had a training yesterday on appraisals. That is also a new realm that we're entering in and learning on. So here are the protected classes. So we have it broken down by federal, state, local, and then also additionally, if anyone receives HUD funding, there is additional protected classes as well. So federally, we have race, color, so skin color, national origin, so where somebody is from, sex, which includes sexual orientation and gender identity, religion, disability status, both mental and physical disabilities are covered, familial status, so the presence of children under the age of 18. And then again, if you receive HUD funding at your property, you're a HUD funded property, you have additional protected classes to be aware of. So if you don't know, do your homework to figure out if you are in this group. Marital status additionally, sexual orientation, gender identity, and then they also have an expanded definition of family under the HUD Equal Access Rule. And these links in here are clickable for you to look at those and do some research on those. Additionally, at the state level, under the Elliott-Larsen Civil Rights Act, we have more protected classes in addition to the federal ones. Marital status, so whether or not somebody is married, single, widowed, or divorced. Age, if you're in a legal age to enter a contract, so 18 or older or emancipated. Sexual orientation and gender identity and gender expression, which are new and I'll talk about in a moment. And then locally, there are a lot of additional protection classes, depending if you have a locality that has some. So Grand Rapids has some additional ones. Kentwood has some, Wyoming, I believe, and Holland. So are some of the ones near us in the Grand Rapids area. However, if you're from anywhere else, you should really check and make sure. We did provide some resources there for you able to check on those to see if there's any additional protected classes in your locality. And if you're in a big apartment complex type company, you may have, different protected classes depending on where the location of that specific property is. So that's also something to be aware of. Some updates to the Elliott-Larsen Civil Rights Act. In June of last year, it was amended to include a more defined definition of race. It now includes it's inclusive of traits historically associated with race, not limited to hair texture and protective hairstyles. What is included in this are braids, locks, and twists. This came out of, there's a lot of areas along the United States that are having these kind of Crown Acts come online. And it came from an employment case because a lot of fair housing laws are also, the protected classes are often protected in employment as well. So this came out of an employment case. And CROWN stands for Create a Respectful and Open World for Natural Hair. Additionally, in that time when it was being amended, they also added additional protected classes. So sexual orientation and gender identity was added and made put into law in February of this year. So as of February 2024, sexual orientation, gender identity, or expression is included in the state fair housing law. So gender identity or expression means having or being perceived as having a gender-related self-identity or expression, whether or not associated with individuals assigned sex at birth. Sexual orientation means having an orientation for heterosexuality, homosexuality, or bisexuality, or having a history of such orientation or being identified with such orientation. So a big thing with fair housing laws is that even if you're perceived or discriminated against because someone thinks of you of having a certain protected class or identifying a protected class, maybe you're not a person with a disability, but they discriminate against you because you have a disability. They think you have a disability, or they discriminate against you because they perceive your sexual orientation to be something that it's not. That is still discrimination, and that is still protected under fair housing law. There are some pending protections currently, so this is something to just be aware of as you're going through your work, that this may come online. Source of income, but passed both in the House and in the Senate. However, from my understanding, they weren't identical, so they need to now make them identical and then pass them again together, like a joint one. And so what this would include is sources of income that would be protected would be subsidy programs, including housing assistance, public assistance, emergency rental assistance, veterans benefits, Social Security, SSI, or other retirement programs. So source of income protections is a protection of any type of income that you receive should be counted towards the income, and it should not be the type of income should not be discriminated against. It does not include income that is gotten in a illegal matter. And it does have an exemption for small landlords with less than 5 units in Michigan. And then again, the housing agency is tasked with handling vouchers within 30 days. These would also amend both the Tenant Landlord Act and the Elliott Larson Civil Rights Act. So going into kind of the state of fair housing, this was a report that was put out by the National Fair Housing Alliance. And they kind of looked at the transactions or complaints by transactions in 2023, and the largest percentage of complaints that we receive in both us as well, which we'll talk about in a minute, but nationally is rental, which includes maintenance. So 83% of fair housing complaints last year were taken place in the rental process, which includes maintenance. So just something to be aware of, that it is happening. It's a very large percentage of it occurring. And then you can kind of see the breakdown as well of other types of cases that were received in 2023. I have another poll for you this morning. All right. Is sexual harassment covered under fair housing law? True or false? There was a little hint in the last slide too. I didn't notice that. About 10 more seconds here. righty. 88% of you were correct. Sexual harassment is covered under fair housing law. It is covered under sex discrimination. So looking at the Fair Housing Center of West Michigan cases in 2023, we had 140 cases last year. In previous years, we had over 200. So it was a bit of a lull, but that was more due to allowing people to self-advocate on their own. So a big majority of our caseload is disability-related discrimination. You can see there so we had 72 cases last year. Followed by race and color, and then familial status. Those three tend to be the top three allegations in our time. Disability status has been on the rise, I should say. It's been consistently on the rise as being one of the top for the past almost 10 years. So, and then you could kind of see the breakdown from there. Source of income is a big, surprisingly, a fourth one, only because it is only protected in localities. So there is a big rise there that we're seeing, difference of treatment because of source of income or not taking sources of income. So that is something we're seeing in the local areas that do have those protections. So Grand Rapids is one of those that does have that protection. And then looking at our cases breakdown in 2023, 52% of our caseload is rental. And then the other big chunk that we have is reasonable accommodations at 33%. So that is something we'll talk about in this training, but it is something that people with disabilities are not being allowed or are having a lot of issues getting to have a change in policy. So after they've moved in or even before they move in. And then we do have a small section of sales and harassment as well. And then the other ones are kind of all some small slivers. So I'm going to turn this over to Liz to talk about some criminal background.
Yes, thank you. So we already had a question in the chat, and we love questions. Please use the Q&A if you can. It's easier for us to find and respond to questions. But this, the question was, I thought this was protected, kind of thinking. And there is HUD guidance, so that can be a little bit confusing in terms of, is it actually a protected class? So what we're going to look at right now is the HUD guidance that does cover both the private market and then any properties that do have federal funding. Any public housing agencies or housing commissions have a separate set of guidance as well. This is a very hot topic. There's been a lot of cases built off of the background screening guidance that HUD has been working on, really beginning in 2015 for public housing agencies and housing commissions, followed up in 2016, 2022 for the rest of the market. So really this applies to essentially any housing that's being offered. We also have a handful of cities in Michigan that have adopted some sort of arrest record or criminal background as a protected class within their city limits. So as I mentioned in the Q&A, I think Detroit, Jackson, and Ann Arbor immediately come to mind. Those laws are being called fair chance or fair access laws, and they are essentially adding having a criminal background as protections. There has been efforts at the state level here in Michigan to add that as a protected class. So those bills have been introduced at least twice that I can think of offhand. So this is really something that has continued to evolve, and there's a lot of activity. So we'll talk about focusing on kind of the 2022 and 2024 guidance that HUD put out. So at the federal level, it's still not a protected class, but HUD acknowledged that nearly a third of US adults have a criminal record of some kind. And many of us understand and know that accessing housing with having some sort of criminal background, especially a recent one, can be very, very challenging. That makes it hard to get employment, and we kind of have just kind of this spiral of barriers for this population. So I encourage you to check out the guidance, because there's really good data there, and it really explains a lot of the thinking behind this. We did also send an email with attachments that have some resources, including a criminal background fact sheet that we put out. And it kind of explains a little bit more how we can bring fair housing cases, usually on the basis of race or national origin, because we find that criminal history screening policies often have a negative impact specifically on those protected classes. So there's different types of legal theory. And briefly, it's a policy is written with the intent to discriminate, or it's a neutral policy, but when you put it into play, when you use it and start applying it to properties, applicants, and tenants, it actually negatively impacts protected classes, even though it doesn't seem like it would. It doesn't include discriminatory language, but when it's put into practice, it is discriminatory. Or there's a refusal of properties to make accommodations. As Bree mentioned, those are requests that people with disabilities can make to policies, which would include screening. So that's kind of how the Fair Housing Act can be brought to use and challenge some discrimination on the basis of having a criminal history. The 2022 guidance brought out some interesting points, and I think it helps explain why this is really being explored so thoroughly. There's been a lot of research and publications that have really established that criminal history is not a good predictor of housing success. So that means essentially that screening tenants for criminal history actually really doesn't tell us whether or not they will be a good tenant. So they introduced that idea. It's not any change or requirement necessarily, but it puts it out there that we're spending a lot of time and effort and money on screening when it actually really isn't beneficial to telling a housing provider or landlord whether or not somebody will be a good tenant. So it introduces the idea that maybe we shouldn't be using criminal history as a screening tool if it's not really going to help us figure out whether this is a good tenant or a good candidate. It gives us examples of what would be violations. And these are kind of some basics that I think apply across the board, whether we're talking about criminal record or not. But, providing all applicants the same information, that would include any accurate information about a criminal record policy. If a property is not applying that policy consistently across the board to all applicants, that would violate the guidance. If a property is rejecting comparably qualified applicants based on criminal record, but taking into account a protected class like race, that would be a violation. This is something where we've seen women with felonies are accepted at a property, for example, but men with felonies are not. And that makes it a gender discrimination issue. And we've also seen properties kind of use discouraging language, maybe to applicants of color, while encouraging white applicants, offering applications or withholding applications, also based on a protected class. There is all violating this guidance from HUD. They gave some specific examples that we always like to share because this establishes that there's some protections that do go beyond just the application process. As Bree has mentioned, there's a lot of differences in treatment and rental that includes maintenance services. And for housing protections go beyond just the application process. Here's an example from HUD that's saying a housing provider that evicts a Latinx tenant who's convicted of a crime, but doesn't evict a white tenant convicted of a similar crime, that's a fair housing violation under this guidance. After learning that an applicant was previously homeless and hospitalized for mental health issues, if a management company departs from their normal standard and starts screening this applicant, well, first of all, you never want to deviate from your normal standard without doing some fair housing assessment. HUD says this would be a violation as well. So we share best practices, and a lot of this is about writing policy and procedures, but we also want everyone to know that not only do you have fair housing responsibilities as housing professionals, but everybody has fair housing rights too. So we always want to make sure people are aware of their fair housing rights, and hopefully you never have to bring a fair housing claim, but friends, family, people in your life may need to know about these protections. So we want to make sure you're aware that these are all protections that we all have and could use. So again, some recommendations I think that are really important is trying to establish policies that everybody can follow and apply across the board. Some of the suggestion HUD makes are, potentially not screening for criminal record or waiting to screen for criminal history after first verifying financial and other qualifications is a good idea. In 2022, we also started to see some guidance that was acknowledging a lot of properties use software or third-party companies that use software to screen applications kind of automatically using computers, things like that. These algorithms that are designed to run these software programs are often developed with racial bias. So we've talked about in the past, cases against Facebook, for example, they use all kinds of algorithms Now artificial intelligence is coming online and more widely available. So we're also looking at the racial bias and those kinds of tools that people often use. So we'll pop to the next. So there is brand new guidance as of Fair Housing Month this year, April. There's a separate set that talks about how housing opportunities should be communicated and advertised, especially using those online platforms. And then we'll look a little bit more closely at the one that looks at tenant screening process as well here. I think this is really timely because HUD has been aware of these third-party screening programs. There's been multiple lawsuits as we've understood how people are being screened out, and we've seen racial bias and the impact that what we think would be neutral software is making decisions. Housing providers are using those decisions based on what the technology is pulling. Well, we know there's a lot of flaws in the data that's out there. There's a lot of flawed data in the court system where a lot of this information is pulled from. So we're kind of understanding this all better. And so HUD has put out this guidance and also includes, what violations would be and how we might make sure that we avoid discrimination in screenings. One of the things that I really like about this new guidance is that it's very common sense. There's a lot of information behind this, but I just want to quickly review these kind of guiding principles that have built upon all of the last several years worth of guidance. And really it's that properties should be using relevant screening criteria. So we're really looking at behavior that is tied to the property and the people. How do we keep the property and the people safe? What's relevant to that specifically? We only want to use accurate records. There's a lot of bad information out there, as I said. We want to see properties following their policy very carefully and consistently. Something that I think is missing a lot of times is being transparent with applicants, simply giving them the information about how the decisions are being made, having a conversation about what that looks like, allowing them to correct or challenge information that's included in those reports is a really good way to kind of reopen housing opportunity because it is a compliance issue. There's also a second set of considerations that I think are really important, especially as we have this kind of record housing shortage. So many people really struggling to maintain the housing they have or find housing that meets their needs. And so HUD specifically calls out credit history, eviction history, and of course, criminal records. But with credit history, a lot of housing providers gather that score, kind of look at setting a standard and apply it, which is still allowable and is still equal treatment. But this guidance raises the question of, does credit history really help us, again, tell whether somebody will be a good tenant? We're trying to establish that they pay their rent and that they will continue to pay their rent. Is there another way we can look at it? Because credit history really was a system put in place about whether or not somebody was a good loan applicant. And so how does that apply to rental housing? It doesn't necessarily. So maybe we should just focus on income verification, kind of simplify it. For eviction history, again, a lot of flawed data out there. So they raise the question of, why don't we find out what happened? Have the circumstances changed? What caused the initial problem? Have they addressed that? What if it no longer applies? So again, a better way to kind of assess, is this person going to make a good tenant? With all this new understanding and better data to evaluate these questions. So again, some other quick thoughts that we covered this point, but before someone is evicted, before someone loses their housing, I think it's a really great idea for housing providers, and HUD backs this up to say, give them the opportunity to have that exchange of information. Give them information that's being used to make the decision, have that individualized assessment, only evict as a last resort. Other things that shouldn't happen, never evict a person or a family because they've been victims of a crime. If they have been a crime perpetrated upon them, they should not lose their housing. Specifically, HUD says properties should not ban tenants' invited guests from visiting based on the guest's criminal involvement. That's something new that we haven't seen before. And of course, you'll hear us say all morning, we want all documentation to be made and to be maintained. That's a best practice of maintaining those records. So what can we do? Again, it really is tying any screening criteria, if housing providers are choosing to screen, back to resident safety and property safety. So differentiating between convictions, not arrests, related to keeping people safe, and differentiating between, crimes like homicide, sexual assault, or arson convictions, and criminal conduct that doesn't tie to keeping people or property safe, like gambling or prostitution. We really have seen a lot of cases successfully striking down any sort of no felony policy or just blanket bans that prohibit applicants from having any sort of criminal history. So those really have been found to be cases that someone can't defend and say this is not racially discriminatory. They have been found to be racially discriminatory. And again, gathering that information, looking at how much time has passed, focusing on the facts, those are all things that should be in practice at rental properties. That individualized assessment is really critical for allowing for accurate information to be provided and reviewed. People should be allowed to submit additional information, like maybe they have some sort of security clearance at their job. They can show they have a good tenant history at the last place maybe they were living. And also this should allow for people with disabilities to make accommodation requests to the screening policy. Maybe they now are in treatment for a disability that was previously contributing to behavior that would have been problematic under these types of policies, things along those lines. So leading back into disability status, I will turn it back over to you. But I do see one question in the chat though, real quick. If someone is lying on an application about a criminal eviction, that just goes to what the guidance is trying to get at, is using accurate information from both parties to make the decision about the housing access. So accuracy is important. And if somebody is misrepresenting that history and you can prove it, then that's all about kind of maintaining that set of records so that you can show the work that both parties did. But again, really the guidance is saying the information that's used should be accurate. So we'll focus on disability status now.
So yeah, moving into disability, as mentioned, it is our #1 allegation of discrimination. And you may be thinking, how does this affect me as a maintenance worker? And we will talk about that. But first I will discuss what is disability and what is it defined under fair housing law. So disability both covers mental and physical disabilities. It's defined as under fair housing, a physical or mental impairment that limits a major life activity. Having such a record of an impairment, or again, that idea that I had mentioned earlier, being regarded as having such an impairment. So what is a major life activity? It's very broad. It's anything from sleeping, walking, bathing, to driving, seeing, and hearing. It's a very range, anything that really affects something that you need to be able to work, do social activities, things like that. For people with disabilities, there's 2 ways for them to have equal access and enjoyment to their housing, which we'll go into. Reasonable modifications and reasonable accommodations. And then linked there are some joint statements by HUD that kind of, if you have a question, we often use it, use the control find feature in Adobe or your PDF reader to kind of look, it's laid out like some Q&As. It's just like frequently asked questions regarding modifications and regarding accommodations that both HUD and the DOJ have answered, and has a lot of good information. So what are reasonable modifications? They are structural or physical changes to the unit to allow a person with a disability to have physical access. So examples of this would be a ramp to an entrance, grab bars, lever door handles versus a doorknob based on ability to grip. As you can even see here in that first photo on the far left, it's even just the beveled ledge at the bottom. That's what that one is showing. Before it was kind of a step up, and then a person with a disability requested that have a beveled ledge for them to get over it with their wheelchair. And I also want to mention, as for housing providers and people that provide housing, it is required for them to allow these modifications to occur in the housing. So that is an allowance that a housing provider must need if a person with a disability needs it and has a disability related need for it. And as maintenance workers, you may come upon this and it may just be a request as just maintenance needed in the unit, and you may not know that it is actually a reasonable modification for that person with a disability. So that we'll talk about some best practices around that later on, but it's just something to keep aware of as you're doing your work. And yeah.
Yeah, I think a lot of modification and accommodation requests go to maintenance staff because you are out and about on the property more often. People may see you and know you. So really your responsibility is to be listening for any sort of health condition or disability related need and identify it as a potential modification and accommodation and make sure whoever needs to know on your team is aware of this request so that the work can get started. And they may not say anything specific about disability or disability related need. It may be as simple as, my vertigo is getting worse, so my doctor recommended I have a handrail or grab bars in the shower or something along those lines. So have the antenna up to identify those types of requests.
Yeah. And there was a case that came out of Michigan, a local fair housing center. It is linked in that blue MI there. But in July of 2019, Donald Davenport applied for an apartment in Oakland County. They were moving to my camera is covering to Michigan from Kentucky to be near family. So they can family could help take care of Mr. Davenport. They found two ground level apartments that were well suited for him and with walking distance of his stepdaughter and his co-caretaker. They took prompt action and they put down a security deposit and they asked for permission to install structurally sound grab bars in the shower for him at his own expense. So a thing with modifications is if you do not receive federal funding, if you're not a HUD subsidized property, that cost does go on to the tenant. The tenant does have to pay for the modifications. If you are in a HUD subsidized property, you, however, do need to pay for those modifications. Just as a little side comment there. Mr. Davenport had a neurodegenerative disorder. I'm assuming it's similarly to a cerebral palsy, but a different type. Stability was an issue. And so those structurally sound grab bars were really important for him to be able to shower on his own or with additional help. So the disability does hinder his mobility and affects his physical and mental capacity. So he can stumble and he has limited muscle control. His eye will fix in one position, also limiting his ability to see and react to his surroundings. So he always needs some form of assistance, especially moving from a walker to a wheelchair. It was best for him to have a flat ground level with no carpet or stairs, grab bars in the shower that are drilled in so he can independently stand and get fully cleaned. His previous housing had accommodated his disability and maintenance staff following the installation and instructions to securely fasten those grab bars by drilling screws into the studs behind the shower wall and then using a sealant around the metal plates. This both provided stability for him so he could stand in the shower on his own, and the installation did not cause any leaks. However, he had met with the head of maintenance to show him at that new Holly apartment complex. He met with the head of maintenance who showed him 2 accessible units on the ground floor. There were no curb barriers, no steps, no internal stairs. So they jumped right on this. They were excited about this. They applied and they got permission from the regional manager who said she would need to check with maintenance, but accepted an application fee and holding deposit and gave them a move-in date. So she accepted everything, said she would check with maintenance and get back to them. In an email to give them the approval to move in, she told them after speaking with maintenance that the grab bars that they would approve were unsecured suction cup bars. She acknowledged even that they're not as sturdy. So she even knew that this was probably not what he wanted. This wasn't what he wanted. And it wouldn't be good for him. She acknowledged that. Further expressed concern that drilling grab bars would leak and or hold pockets of water. Suction cup grab bars would be very dangerous for Mr. Davenport as his disability related needs, and the family addressed that that he needed that, and then they addressed the concerns about the possible leakage using wooden studs, metal cap, caulking, etc. Some tubs have tile tub surrounds and not fiberglass. There was concerns given about where the wooden studs would be located in addition to the fiberglass. The sorry, the property supervisor, or the person they were communicating with, had stated that the maintenance man was not on the property and could not recall the upcoming unit's bathroom walls. But she said that she would speak with her supervisor. So they were really giving them the runaround on this and just not really listening to them and hearing them on what he needed. And, it is a concern when, as a housing provider could have, that things should be structurally sound. It should not, mess up the structure of the home. However, there were solutions to this issue and that they were not really listening. The complex then stopped communicating and rented out those units to people without disabilities who paid their deposits even after the Davenports. So even if you were following your normal standard procedure, they had already accepted a deposit and holding fee for the unit, and then they continued on with other applicants, which is just more of a bad business practice as well. A federal court lawsuit was filed and in violation of the Fair Housing Act for them refusing the reasonable modification request, and that the suction grab bars were insufficient for his needs. The apartment complex did deny liability, but the parties were able to reach a settlement that included placing an anti-discrimination policy on their website, fair housing training, and a disability rights notice on the application. In the end, though, Mr. Davenport had to move to an apartment that is way less accessible, more expensive, and farther away from his caretaker, which is just really shows why fair housing and housing choice is really important, because this unit was perfect for him and everything was working out. And it was really came down to the housing provider not giving him that reasonable modification for his disability related needs. And in the end turned into a way more expensive, less accessible, and less wanted unit. That was it's really unfortunate for Mr. Davenport. We do have some videos to share here. They're kind of more for empathy. They were done in an empathy training. I'm just going to show one, and it kind of shows, it goes through what types of accessibilities people with disabilities may need. We'll watch the doors one. So in this training, they're trying to replicate, trying to get into an chair. Just kind of showing the challenges that make certain widths and type of entries.
The benefit of a slightly larger door frame beyond 32 inches I think is really helpful, as well as having a completely flat surface to navigate on. Yeah. This link will take you to the whole video, by the way. There's other exercises to look at, just kind of help us understand what it's like to navigate using different adaptive equipment as a person with a disability.
Yeah. And those videos were put out by the Fair Housing Center for Rights and Research. So when you're thinking about reasonable modifications, there's some questions you could be asking yourselves. Who will use it? Will there be any issues regarding code compliance? Is there documentation needed? If the disability is not visible or known, there may be documentation needed. If there are plans or drawings, who pays for it? As I mentioned, it depends on how the property is funded. Private housing, generally the tenant pays. Federally funded housing, the housing provider pays for it. Think about what happens when the tenant moves out. All these questions are very valid and requires homework, but that is something that we can help with. So if you are having issues with or understanding some modifications, definitely kind of you can reach out to our office and we can walk you through those. Again, we cannot provide legal advice, but we can provide best practice information and our understanding of the law. Have another quiz for you here, making sure you guys are all awake with me. So for this one, you don't have to do anything if you feel a request for a modification should be declined. True or false? Give folks about 20 more seconds here. All right. And the majority of you got that correct. False. If you feel that a modification should be declined, it is important, obviously, do not decline it up front. It is really important to understand what the person needs, what is their disability related need. And if it's something that cannot be done, like physically, it's just not possible, then it should be up to you and who you're working with, even the person requesting it to work out other options that may work for them. And in the end, sometimes if the housing is no longer fit for their needs, they could request a reasonable accommodation to get out of the lease early with no fees or penalties because the housing no longer fits their needs if they're a person with a disability. If they're on the second floor and you can't put in a chairlift, you can't put in a ramp, things like that, whatever the case may be, if they can't get to their unit, then they shouldn't have they shouldn't be penalized for getting out of that lease. But as a housing providers and as people working in the housing, it's up to you to think of other options work with the individual to think of options that would work best for their disability. And as you as maintenance staff, the buildings probably the best, I would say the best, and know what is capable and what is possible for the units. Reasonable accommodations. Those are changes in rules, policies, or procedures that are needed for a person to have equal access and enjoyment of their housing. Some examples would be obtaining assigned accessible parking. A big one that we often hear about is waiving a no pet policy with a person with an assistance animal. Maybe allowing a live-in aid or home supports, allowing time for hoarding assistance services to bring the unit up to lease compliance. Those can be, hoarding is considered a disability. So these are changes that the housing provider has to make in order for the person, has to make for their policies or procedures in order for a person with a disability to have access to the home. An example here, there was a independent and assisted living that was tested in Arizona on behalf of a grandfather, Frank, who was deaf and uses ASL to communicate. So testing is how the Fair Housing Centers can assess the housing industry on if they are being discriminatory or not. So testers go in and act as normal home seekers and just ask questions and see how housing providers respond to those questions. So in this case, they were asking what they would do if somebody was deaf and needed to use ASL to communicate. So the granddaughter stated that he would be moving from Florida and they mostly exchanged written communication. The tester asked what accommodations would be provided. The staff responded that they would likely use pen and paper as there was no staff with sign language abilities. The manager did state that it would be something that they were going to have to figure out together, Frank and all of us. She further stated that they would find Frank's comfort zone for communication. She expressed a willingness to meet with Frank to assess his needs and whether Chandler Villas would be a good fit. So that is a big red flag. When housing providers are trying to assess needs and whether that somebody would be a good fit for their housing, that is a big red flag when it comes to fair housing. She stated that she had used lip reading in the past to communicate with deaf individuals. Staff would knock on the deaf resident's door to conduct a safety check. Staff stated that Frank would have to pay for and install his own auxiliary device, a doorbell with a flashing light to know when someone was present. Staff further stated that all residents have a life alert button they can use in case of emergency and a special phone so that staff could check on him if he did not come down for a meal. They asked, these are some quotes that went back and forth. Would you guys be able to put in like a light, so like if somebody knocks on his door, rings his bell, because that's what he has in his house now. He knows if someone's at his door, he can install that. And if he doesn't come down for breakfast, we're calling it. If he doesn't answer, I'm sure he has a special phone too. If he doesn't answer, then we'll go over and knock on the door and check on him. So they weren't really being accommodating. They were really putting it on him and not really being accommodating to his disability and his disability related need.
Not recognizing that he won't hear the knocks, he won't hear the phone ring, and their standard policy just does not work in this situation.
Yeah. They were then legally required to provide a doorbell accommodation to Frank free of charge and did not require him to install it himself. Deaf residents were treated differently compared to hearing residents because hearing residents were able to hear a knock on the door, whereas deaf residents were not able to hear that knock and missed the services. So this was I want to go back. This was an assisted living home. So this was a place that would have a higher population of hard of hearing residents. And so that really showed that they were not willing to really work with these people with disabilities to provide accommodations that would best fit their needs. So that was a real shame. They never offered to provide him a flashing doorbell, a special phone, or an alternative auxiliary aid for Frank. There were safety check systems designed for hearing people, but not deaf individuals. If there was an emergency, he may not be able to be notified in time. So there was a really big safety concern as well going on here. Turning away maintenance staff for non-emergency repairs was another issue. I was like, what is this? Sorry.
Back to Michigan case.
Back to Michigan. My camera is covering the state, so I did not see
that. That can be tricky with all the Zoom settings.
Yeah. So this is another Michigan case. Maintenance staff was turned away for a non-emergency repair for somebody that was in labor at a high-risk pregnancy. And then when that person returned, they found a notice to quit on their door because a lease violation for refusing maintenance. The local fair housing center advised her to make a reasonable accommodation request. She submitted proof that she went into labor shortly after they came to her door and proof that she was at high risk for it was a high-risk pregnancy. However, the housing providers still decided to pursue the eviction anyway. They continued to bother her in a seemingly way to catch her in a lease violation. At a meeting, the housing provider agreed to dismiss the eviction if she moved out, but that's not what she wanted. The housing provider that took her to court 4 times, only to dismiss the eviction once the fair housing lawsuit was filed. Despite loving the location in the apartment, she ended up moving away to protect her family and her emotional health. So this was just a really bad case where there was some harassment going on as well. And harassment is covered by a housing provider, is covered under fair housing. So thinking about reasonable accommodations, what does an existing policy or rule say? What is the standard procedure or service, and how does the reasonable accommodation request differ? Again, if the disability is not known or obvious, is there documentation needed? When or how does the policy get changed? Again, needs homework, and these are questions that we can help you answer if you're going through a reasonable accommodation request. Reasonable sorry. Oh no. Reasonable modification requests can be made verbally or in writing at any time, and they should be accepted and addressed regardless of how they're made. So, as we know, reasonable accommodations can happen. You know, they don't also have to happen at the beginning of sorry, let me start over. Getting ahead of myself. As we all know, as we change in life, our abilities change. And so disability, we may have different disabilities appear as we're living somewhere. So accommodations or modifications can be made also again, at any time. It does not have to be at the beginning of the lease or, halfway through the lease. They can be made at any time. They should also be evaluated and decided on a case-by-case basis. The modifications must be allowed for the most part, and federal funding also increases your obligation to do so. There also should be no fees or deposits charged for any accommodations or modifications. When talking about reasonable modifications and accommodations, it is based on reasonableness. What is reasonable? And as a housing provider, there is some undue or some things that you can ask yourself. Is this reasonable? Does it provide any undue financial or administrative burden? Is this something that would fundamentally alter the nature of the housing provider's operations? Maybe somebody can't drive because of a disability, requests a bus, requests transportation, and that's just not anything your housing can provide. You don't have staff to do so. So that would be really a change in your operations, and that would not be reasonable to request. As mentioned, if the original request is unreasonable, what are some alternatives that will effectively meet their needs? This is what HUD refers to as an interactive process. So it needs to be having back and forth between you and the individual.
And alternatives must be offered. If the first response is found to not be reasonable, you have to continue the conversation, do the research, make sure that their need is addressed, up to maybe even letting them out of the housing penalty free, because the modifications that are needed are too extensive or are not reasonable or would violate code. That's not reasonable to violate code. So that we consider as kind of like the last accommodation.
Yeah. We do have some resources that would help with disabilities, so feel free to check those out. And then I will pass it over to Liz to wrap us up with some best practices and tools and resources.
Thank you, Bree. So yeah, these are best practices specific to providing maintenance services. So we want to spend just a few minutes looking at these, but we'll start with a quick poll here. True or false, and hopefully I can get this launched. Here we go. True or false? What do you think? Every maintenance request must be addressed in the order it was received. And I'm seeing some very fast answers on this, so I appreciate the quick on the draw for polls. And also just a quick reminder, we will be providing the link for the evaluation where you can request a certificate in the chat. We'll post that a couple times here as we get towards the end of the class. I don't think it popped open in your browser, so we're going to start posting that link for you. So keep an eye out for that from Lindsay. We got this very quickly here, but maybe 15 more seconds. Oh, yes. And a good reminder, if you're watching as a group, each of you must individually complete the survey so that we can track your attendance and follow up if you request a certificate. If you're watching as a group, make sure everyone gets the link. If you're calling in, I think I saw an iPhone earlier. We don't know who you are, so please email us with your phone number and your name too. Okay, I'm going to go ahead and end this poll, share our results. So we had a difference of opinion here, which I think is probably due to some of the details behind this question. Generally, treating each request as it comes in is a best practice. So I would agree with those of you who said this was true, but we'll kind of go into some details here where we understand that when unique circumstances like emergencies or accommodations and modifications come up, we might have to deviate from our standard practice. So a bit of a trick question there. Thanks for playing along with that one. I'm used to moving the slides. I forget I can't do that. So we can check off this first best practice here as you finish this class with us this morning. Knowing your responsibilities is really important. Knowing the protected classes and the new guidance that's out there, not only does it help you professionally, but those are your protections as well. So we can help you figure out what your local protections might be. As Bree mentioned, Grand Rapids has a local ordinance, Kentwood, Wyoming, Holland, East Grand Rapids, Traverse City, multiple cities, about 40 cities across the state of Michigan have local fair housing ordinances. So build your list of best practices. And anytime you're not sure if something that you're working on is a fair housing issue, check that list of protected classes. If you're thinking about a maintenance standard that would impact families with children or people with disabilities, you've got to assess it with your fair housing hat on. Equal treatment is really important for fair housing. It's important to resist the urge to provide any preferential treatment to avoid fair housing risk. Some residents who don't get preferential treatment may feel like they're being discriminated against, even if that's not the case. So we really train from a conservative standpoint and encourage you to really stick to your policies. An example here would be somebody stops you, you don't know them well, they ask for a repair, you follow your policy, tell them it needs to be submitted in writing. If another resident stops you that you know well and asks you to do a quick repair and you don't recommend they follow the standard practice, that creates a difference in treatment. So it may seem small, but everybody has represents multiple protected classes simply in who we are. So it's really best to provide that equal treatment and follow your policies. As we said, processing requests in the order they're received is a good basis. We understand that emergencies will need to move to the top of the list if there's water shooting out of a pipe or, doors that can't be secured, windows that don't lock, any sort of gas leak, things like that must, of course, be addressed first. But generally, first come, first serve for background kind of non-emergency standard maintenance is a good idea. Essentially, just setting up a process where you can show that you do provide equal treatment. Good idea to pretend like you're being challenged by a civil rights investigator and kind of go through how would you show what you do and make sure you're documenting that. We also think communication is really key. And often I think miscommunication can lead to fair housing issues. People feel like they're being ignored or their concerns aren't being addressed, or they simply don't hear anything for weeks at a time. This is unfortunately something that we hear from our clients where they're never responded to, or, they don't have updates, information, okay, we ordered the grab bars. Now there's a delay in the shipment. Let them know, call them every Tuesday and say, we're still working on it. I think that can be really helpful. Written policy is really key. That helps everyone kind of be consistent. You can tell your residents what your policies are. You can document how requests are made and handled. This is really important, especially if a routine maintenance request does turn into a disability-based need for an accommodation or modification. Someone may ask you to move the location of a light fixture or a switch, lower the towel rack, lower a surface in the kitchen, and it is actually an accommodation or modification request. If they're not clear about that, it's your job to kind of assess and make sure you're watching for those types of requests, so that they can be not only recognized, but prioritized. So emergencies aren't the only times that may justify making an exception to a first come, first serve policy. We have clients who are not able to use their bathrooms or not able to prepare food for themselves because an accommodation or modification request has been ignored or delayed and delayed and delayed. So an unreasonable delay, many judges will say that's essentially the same as if the housing provider said no in the first place. So you really do want to take action and prove that you're taking action. And in some cases where people are not able to take care of themselves or it interferes, endangers their health and safety, those are the types of requests that should take priority. Be careful with fraternization and take steps to prevent sexual harassment. This is something that unfortunately is on the rise the last few years. Property owners, managers can be held liable. If people know that this is happening and they don't take action, that especially exacerbates the case. I mean, we've seen $500,000 decisions coming out of properties where people knew it was happening and didn't take it seriously and didn't stop the sexual harassment. This is critical. I think I mentioned, being careful to not fraternize with residents. This can be misinterpreted. So it's best to maintain a professional presence. If you are friendly with someone and ask them to meet you for lunch, they may not be interested. This is your professional role, so we really encourage not fraternizing with residents. Same thing with if someone is maybe not prepared to answer the door or let you in for scheduled maintenance. If you find yourself in a compromising situation, maybe they're not sober, maybe you can smell alcohol or other substances, you want to document those circumstances and recognize when it's best to reschedule. If somebody's not appropriately dressed, you can document that, offer to come back at a more appropriate time and let management know for sure. Just a small fair housing observation here is respecting people's privacy. If you make a comment on some items in their home that might have religious or cultural significance, it could create fair housing risk. They may not want to talk about that, or they may feel like it might disclose something about themselves that they don't want to share. So it's best to focus on the work, be polite, thank them, and leave. We have a great resource for accessibility, but this is where I usually take an opportunity to remind folks to keep access aisles free of snow, make sure that any buttons that are electronic that open doors have a clear path. I see flower planters and trash cans often put in the way of accessible features. It's really important that those spaces remain clear so that people can safely traverse through the area and come and go from a building. It's a great idea in your communication to focus on your property, focus on the services that you're offering, focus on the maintenance that's underway, and not the people. There have been fair housing cases where maintenance staff have been stopped by prospective tenants or people taking in tours, and they've said something discriminatory, like, oh, we don't have a lot of families, or we're not really set up for you at your age, or basically discouraging potential applicants, and you can be held liable for those types of statements. And just also a quick note, any outside contractors should also be vetted for fair housing knowledge and experience, because there's a chance that selecting outside contractors that are that do violate fair housing, that liability could be attached to owners and managers of property. So a good idea to ask them the question, when's the last time they had fair housing training? Keep good records. As we've said repeatedly, documentation is really key. The window for filing a fair housing complaint in Michigan can be as long as 3 years under state law. So that's a good idea to make sure you've got those records to refer back to for at least 3 years, noting any delays for equipment, any issues with delivery or installation, things along those lines. We have a phenomenal resource on our website, our new website, the new as of last summer. You can search by language, you can search by protected class, you can search by different topics, or you can plug in a word, a search term that you're looking for yourself. So really recommend checking that out. Of course, as Bree has said, you're welcome to email any of the three of us and ask for direct information. But if you want to look at our website and find something yourself to download, that's the place to do it on our resource page. Lots of other resources on the website. We have a whole page with different fair housing laws in our service area. And then, as I mentioned, our resource page, you can search for all sorts of not only HUD guidance, but also materials that we have produced with best practices focusing on different topics, as you can see here, not just the protected classes, but lots of other areas. So I think we